You may proceed.
Good morning, if it please the court. In this case...
You still didn't tell us who you were.
I beg your pardon?
Who are you?
I'm sorry. Kenneth Bogill, appearing on behalf of Judge Simpson.
Thank you.
The record in this case, in which the court is conducting a de novo review both as to the Judicial Tenure Commission's findings of fact and its recommendation, that record is clear. That Judge Simpson is a conscientious judge, law professor, and mentor who is active and very well respected in his community, and who takes very seriously his obligations as a judge and has never had an issue with the Judicial Tenure Commission before or since. As I will detail momentarily, the record shows that he did not, in fact, interfere with the police officer at the scene. He did not, in fact, interfere with or delay the township attorney's investigation of Ms. Vargas, and he did not make any misstatements during the course of this investigation. But importantly, the record also shows that Judge Simpson has reflected deeply about all of these events, his relationship to them, and he realizes that even where one's intent and acts are benign, it is important to avoid conduct which could raise even a question about the appearance of impropriety. And an additional point. Throughout the litigation of this case, the effort at getting to the truth has been hampered, I respectfully submit, by the Tenure Commission's prejudgment and, as we ultimately learned, its failure to disclose exculpatory material that it was required to disclose pursuant to 9.208, as this court found in its remand order of last December. With respect to the charge that Judge Simpson interfered with the officer at the scene, fortunately there is a video of virtually that entire incident. And I respectfully submit that the best evidence that shows that Judge Simpson did not in any way interfere at the scene or attempt to interfere is by observing that video carefully. In addition, we have the arresting officer's testimony. Officer Cole testified that Judge Simpson did not do or say anything that suggested that he should do or refrain from doing anything he would normally do in the exercise of his responsibilities and in the exercise of his discretion at the scene. Officer Cole explicitly gave Judge Simpson permission to speak with Ms. Vargas while she was in the police car. Officer Cole suggested that Ms. Vargas' keys and cell phone be given to Judge Simpson. We don't have just that, though. We also have, and this is important because if there had been any interference, it would have been incumbent on the officer to record that in his, first of all, to attempt to stop it, and also to record it in his report. We also have not only his reports, but the review of his reports by his chief, Chief Harshberger, who indicated initially and later that Officer Cole did everything right, and everything by the numbers was his phrase, and that was still his opinion after reviewing the reports, after reviewing the video, as he testified at the remand hearing. Lieutenant McCormick similarly indicated that Officer Cole did everything right, and Deputy Chief Schick testified not only that Officer Cole handled this in a textbook manner, but also that from his review of the material, Judge Simpson had not done anything at all to interfere whatsoever. The absence of the absence of an intent to interfere is also corroborated by Judge Simpson's commendable attitude as to his responsibilities with respect to being aware of Ms. Vargas' arrest as a student of his. He promptly reported her arrest to those he was required to report it to at Cooley. And when she first called him, one of the first things he said to her was to encourage her to call the police. This is all, to me, I think, very clear that there was no interference, no intent to interfere at the scene. The facts stand in stark contrast, for example, to those that were presented to this court in Brown, where the judge very directly attempted to use his status as a judge, and the court properly found that. With respect to the second of the three charges against Judge Simpson, the claim that he attempted to interfere or interfered with the township attorney's investigation, it's clear that he had a legitimate basis for communicating with Mr. Lillick. Ms. Vargas was his intern. She was working for him. It was important for him to determine whether she had been truthful with him, to determine what she had in fact done or not done. That was an absolutely legitimate basis for him to communicate with Mr. Lillick and get a copy of the police, seek a copy of the police report from him. Mr. Lillick also was very clear in his testimony that Judge Simpson did not attempt in any way to interfere with his exercise of discretion and did not delay the processing of the case, and that there was no wink and a nod, since these are two individuals who know each other, have known each other for a long time. Deputy Chief Schick also indicated in his review of the matter that there was no delay. And again, both he and Mr. Lillick indicated there's a broad range of time frames that are involved in the processing of an arrest.
Counsel? Counsel?
Report. Yes, Judge. Justice. Justice Young.
In prior cases, Beverly Nichols Nickerson, Sylvia James, James Justin, Wade McCree, Deborah Ross Adams, and James Noacker. The court has laid down a pretty significant marker that where a judge is determined to have lied, that is so fundamental to the core responsibility of a judge to administer justice and to seek those who appear before him or her to tell the truth, that the very act of lying is disqualifying. It seems to me the most serious allegations, therefore, against your client have to do with the JTC's determination that not only lied in response to the initial inquiry, but lied under oath during the hearing. I suggest you might want to address those, because if the court determines that he in fact lied, not just sort of failed to disremembered, but lied, it's a fairly fatal offense. Not susceptible to temporizing. It might be from a judicial standpoint, fatal to continued service.
Thank you. And in fact, I intended to get there when I got to count 3, and I'm happy to go there right now. The Tenure Commission found that Judge Simpson intentionally misstated the facts in denying having had contact with Ms. Vargas between approximately midnight and approximately 3:30 or 4 o'clock in the morning on the night in question here. The Commission's finding overlooks any number of factors, not the least of which is that in answering the questions that the Commission found to be lead to misrepresentations, Judge Simpson was very careful to indicate the caveat that he didn't believe there was contact during that point in time. He didn't say point blank there wasn't. He said, I don't believe there was, twice, because he wasn't completely sure. He was being careful and specific, and he was expressing his own doubt as to what the reality was, but expressing also his belief that there wasn't. As it turns out, there were 6 text messages between approximately 1:30 and approximately 2:30. That's important on a number of levels. One, Judge Simpson has been entirely open throughout this proceeding that he had a whole lot of contact with Ms. Vargas, including that evening, including that night. She was also candid that there was a lot of contact between them, and I explained it in the context of the case she was working. I'm sorry?
A lot.
A whole lot.
Yeah.
No question about it. No question about it. And that's the second part, which after dealing with this, then I will go to that aspect of the Tenure Commission's finding. It would make no sense to be open about particular communications through the course of a night and then intentionally mislead as to just a couple of communications at any particular point.
And the purpose, but the purpose of them.
I beg your pardon?
The explanation for the volume, and there are stunning amounts of texts between these two individuals that exceed even what I thought preteens and teens could do, but they're here. They're just, it's a wonder that anybody got any work done with this volume. It was the explanations offered for why there was so much communication between these two that was called into question, wasn't it, by both the examiner and the JTC?
If I might, I would like to finish about the particular communications on the night of September 8th, and then go to that, because obviously both are important. Mm-hmm. The last point I was going to be making with respect to the communications during the night is not only was Judge Simpson open about his communications throughout, and there's no reason why he would want to be lack the same openness as to any particular messages, texts back and forth at any particular time that night, to the extent that there's been this shadow, this innuendo throughout this proceeding that maybe Ms. Vargas had been at his house. It was actually to his benefit if he had remembered that there had been texting between 1:30 and 2:30, because obviously if they're texting at that time, she's not at his house. So that, I think, also really goes to the absence of any intent or intentional or knowing misrepresentation. And again, we start with the fact that Judge Simpson was very careful to temper his language. I don't believe there was contact at that particular point in time. Now, with respect to the volume of communications, what we had here was a situation where Ms. Vargas was a student of Judge Simpson's. She had then been hired in July of 2013 to be an intern as well. She very soon after being hired, taken on as an intern, as a non-paying position, was given a series of assignments regarding a particular highly sensitive case that itself involved her reviewing over 100,000 text messages, many of which...
But again, this is troublesome to me, because is it the Nassif matter?
Yes, exactly.
Well, if that's the justification for the volume here, the numbers of communications before that, before it was possible for the judge to be engaged.
The timing, you should get to the timing.
Yeah,
Yeah, no question about it. Okay. Even before the Nassif case, first of all, the misconduct...
Let me put this in context for you.
Certainly.
I think it strains credulity to believe that anyone who is a judge and who appears on an active scene of a post-accident event and introduces himself as a judge and is then permitted to talk to somebody who has been arrested and sitting in the back of a police car has not interrupted the normal procedure. I think that's a very tough argument. Second, as to the involvement of the judge with the prosecutor, I find it very hard to understand an innocent explanation that ultimately resulted in the delay of that case. In fact, the prosecutor, after the two interventions, declined to press charges and found that he had to disqualify himself because of the contact. Now, it may be that there was innocent intent, but it seems to me most judges would say, I overstepped my role as a judge in intervening to assist somebody I have an interest in. I don't care what the source of the interest is, but when you do that, most of us recognize that we have used our office for the benefit of somebody else, and we might do it with all the wonderful intentions, but most of us would say, I'm sorry, I overstepped. Second point is,
okay,
why we then, instead of apologizing for it, taking your lumps, if you begin to fabricate justifications for why you did that. That's the concern I have.
Okay. Thank you very much. First, with respect to whether it should have been done or not, Judge Simpson, from the very beginning, has acknowledged in retrospect I would never do this again.
It's
I
his
think it's-
explanation for why he did that began to cause problems. I'm saying, recognizing he overstepped, if he did, in both the accident scene and talking to the prosecutor, the problem is his explanations about why he did that.
Well, I respectfully disagree with the last part.
Okay.
Judge Simpson has accepted, and I think at least as much as anybody in this room realizes that when you engage in conduct that raises even a question, that was something that he would not ever do again. With respect to being at the scene, put it in the context. Also, he is a law professor who historically has made himself available to students at all hours of the day and night.
I teach too. Almost everybody up here does.
Yes.
I have interns.
Yes.
This is extraordinary. This behavior about it appearing at the scene of an accident in the wee hours of the morning, even if it's close to my house, it would be an extraordinary act. And then to introduce myself as a judge.
Ms. Vargas already had indicated to the officer that he was Judge Simpson, and the officer already knew him from having appeared in front of him.
That.
And I think that if he had declined to introduce himself as a judge when he's known in the community as a judge, would have suggested he's got something to hide when he's not hiding anything. The officer, to go back to other points in your question, the officer at the scene has a lot of discretion. He indicated that he exercises that discretion to allow people to do things. He exercised it here, but not
no one but a
because
judge.
Simpson
I'm
was a
sorry.
judge.
No one
or
but a
had asked
judge
him.
would have been allowed to talk to somebody
I
who had been
respectfully
arrested.
disagree with that, and so did the officer indicated that he exercises his discretion. He lets people approach. He lets people talk. Sometimes he does, and sometimes he doesn't. And this was a situation where, because of the circumstances, he felt comfortable doing it. And again, if he had done anything wrong, we would expect that the review by his superiors in the department would have indicated it. That's one of the many reasons why it's important that his superiors indicated that what he did was by the numbers, it was textbook.
Mr. Mogill, I would like to hear more about the third point that you're talking about, which is explaining to us the justification for some 15,000 contacts by phone, text, or telephone over a few months period of time, and how that somehow has something to do with reviewing documents for a case. I worked on cases and I reviewed thousands of documents myself in my legal career, and I don't remember texting the partner that I was working for or calling during all hours of the day and night. I'm not sure how. It just doesn't make any sense to me, and I'd like to hear you tell me why it should. First of all, there were two purposes involved. First, early on, as the record is clear, Ms. Vargas had been having difficulty with her boyfriend, who was also a law student. She went to Judge Simpson for somebody to talk to, which again is consistent with his role, confirmed by Associate Dean Vestrand, as someone who always made himself available to his students, including any time of the day or night. And we had testimony about a group of students calling him late at night from Ms. Curry. There were many back and forth communications about that before she even got assigned to work on the Nassif case. Judge Simpson knew before the case was assigned to him that it was coming to him. He anticipated a status quo motion and got her going on research. Once the text messages came in and had to be reviewed, there were over 100,000 text messages. There was enormous sensitivity because they involved a local attorney. They involved another local judge. They involved allegations of...
All of that means to me that you would have your intern work in your office while you're there during the day, assuming all this work had to be done. I'm frankly not really familiar with district court cases where this volume of activity occurs, but let's assume that that's what was going on in this case. It was so sensitive that instead of having his intern come to his office and review the documents and talk to the judge, they decided to do this via text message?
She was reviewing documents. She was reporting to him. She was questioning him. I think there's nothing at all unusual about students working late at night. There's nothing at all unusual about lawyers working late at night.
Here's the problem. I don't really care what the underlying relationship is between the judge and his intern, but there's the problem of, it's quite clear that there was a some kind of emotional relationship that would prompt 15,000 kinds of communications, a level of intensity that might explain why he showed up that morning and why he was so interested in talking to the prosecutor. That and it's trying to gloss over that motivation that I think is the biggest problem for your client. That your client does not appear to have been candid in making those explanations.
With all due respect, I disagree. We have no information, of course, as to the content of the text messages, and I really wish we did.
And why is that?
Because it just doesn't, for whatever reason, it doesn't exist.
Were they not maintained on the phone? Does the phone not exist?
You know, I don't know what the reason is, Justice Viviano, but neither side was able to obtain the contents of the text messages. The burden of proof is on the commission. Both Judge Simpson and Ms. Vargas testified there was no personal relationship between them. There was no evidence anywhere on this record of an inappropriate personal relationship.
You misunderstand my point.
Well,
I'm not concerned ultimately about what the nature is, but the intensity of the communication between these two has caused the judge to need, apparently, to explain why he was there and why he made the inquiries of the prosecutor.
With respect to the number of messages, anybody who's using text messages these days, particularly among the younger generation, you go back and forth, back and forth, back and forth. All of a sudden, you've got 100 in a couple of hours, and you've covered very little ground. Or the numbers in and of themselves grow very fast. I have sent texts or emails back and forth with counsel. I'm working on a case any hour of the night and day. And I think when you've got an extraordinary number of messages that she has to review in order, in part, to identify which can be turned over to the prosecutor's office, which would have been protected by Mr. Nassif's attorney-client privilege, et cetera. And there's going to be a lot of questions back and forth. I think that
there's so many things. The Nassif case was interposed as a justification for this quantum of communications. He was arraigned, I guess, and hadn't been assigned to the judge's docket until August 11, 13. But that on the 3rd, the day he was actually arraigned, the judge and his intern had a telephone conversation lasting 3.25 hours, including at 1:20 in the morning. I mean, these are not easily explained as work-related.
But again, they're not all work-related. And Judge Simpson and Ms. Vargas were both very candid. I'm sorry, I beg your pardon.
This was counseling?
He was someone she was, he made himself available, as he has to many other students, to be available when the students are having an academic problem, a personal problem. Ms. Vargas is not from Michigan. She didn't know anybody here to talk to. Her boyfriend was also a law student. She didn't want to talk to other law students.
Mr. Mogo, I'd like to skip ahead just a little bit, if I might. If this court is persuaded that the 3 counts here have been established, I don't know that we will or won't, but assume that for a moment that we believe those counts have been established, that would necessarily encompass the false statements that have been the subject of some of the recent questioning. Why should those statements, in light of the cases identified earlier by the Chief Justice, not result in the removal of Judge Simpson? That is, make the argument, we've established the counts, make the argument that the sanctions urged by the JTC are either disproportionate or they fail to take into account mitigating circumstances that ought to properly be weighed against what are obviously the very aggravating circumstances of his having testified falsely under oath.
Thank you, Justice Markman. Obviously, we apply the Brown principle, the Brown factors here. We look at this as being an absolutely aberrational experience in the course of a long tenure, having been an attorney since '86, a judge since '99. We look at
the good works in the community, the high regard he's held with in the community, the fact that this did not occur on the bench, the fact that this was the decision to go to the scene would necessarily have been a relatively spontaneous and not premeditated decision. The fact that the contact with Mr. Lilick, even if inappropriate, also had a legitimate purpose of determining whether Ms. Vargas had been straightforward with him.
How can that be when she told him, when she was in the back of the cruiser, what she'd blown on the test, the field test?
But he still needed to confirm or see whether she was holding anything back. In retrospect, there would have been a much better way to get that police report and get that information. There's no question about it. But in terms whether, even if it's not exonerating, I respectfully submit that there was a legitimate reason that it would at least be mitigated.
And the legitimate reason for discussing with the prosecutor who her defense counsel should be?
I think the proper context for that is this is a small town, people talk to each other, and it's not two individuals who've known each other.
The one person who knows better than almost anybody in this community who the good defense counsels are, the district judge. Why is he talking with the prosecutor about who he should recommend to his intern?
It's just, with all due respect, it's just conversation. And frankly, it happens in a lot of contexts where one wouldn't expect it. In my own experience, including doing a lot of attorney discipline work, conversations like that with staff attorneys at the Grievance Commission, with individuals. Again, the overall, even if one finds, to accept, Justice Markman, your hypothetical, and I think it would be really turning the burden of proof on its head, but even if one were to find that the counts were made out, I think when you look at the overall context, the isolated nature of the incident, the absolute early on recognition, this is something I wouldn't do again, all the good works, everything that he's done in the community, everything he does as a professor at the law school, the good works with other students, the availability, accessibility, all of that is enormously mitigating and would, to me, counsel in favor of a very reduced
Can I ask you to address the thread of those cases I cited?
Yes.
Is that when a judge lies under oath, it makes it hard for that same individual to turn to somebody else and expect them to tell the truth when under oath. If, as the JTC has found, that he lied under oath, how is it that isn't a fatal act? Why doesn't that alone require that the judge be removed from the bench? I understand there are a lot of transgressions that a judge can do that are not fatal. They're mitigating. There's long service here, honorable service in the community. But there's some things that we are held as judges to that are cardinal. And telling the truth is something we expect of everybody when they're under oath, not just judges. So why isn't that a very serious event?
And again, I strongly disagree with that conclusion. But I think
understand. The premise of Justice Markman's question is, if we believe the JTC has established that case, it also includes the finding that he lied under oath.
I understand. Look at the Brown case. 4 prior admonishments. He clearly misused his authority at the scene in a very blatant way and made misrepresentation. The consequence was 15-day suspension. You do balance everything in all of the circumstances, even if...
If this were only about misuse of office at the scene and with the prosecutor with an acknowledgement, I'm sorry, I overstepped, I'd agree with you. It's the additional concern expressed in the findings of the JTC that rather than confess error, take whatever sanction is appropriate, there was a fabrication attempting to justify the behavior.
I am very concerned that there is inference and innuendo based on mere numbers of communications which are themselves
with all due respect, not unusual, either the volume or the times of day and night, given the way the world runs now. And in terms of late at night, yes, Judge Simpson is busy on the bench during the day. He's got his other responsibilities, including teaching, various community activities. Communications on a research project are likely going to be late in the evening, including late at night. I strongly, again, this is a de novo review. This is not, there's, and with all due respect, I think it is vitally important that you not allow the burden of proof to be turned on its head.
You, of course, believe that all those innuendos not only implicate the conclusions in count 3, but they cast the allegations in count 1 and 2 in a very much different light, too, don't you?
No, there's no question about that. And I thank you very much for your time.
Good morning. May it please this honorable court, my name is Margaret Rainier. I'm the Associate Examiner, and sitting with me is the examiner, Mr. Glenn Page. On September 8, 2013, Ms. Vargas was involved in that accident at 4:24 a.m. In effect, she ran a red blinking light, and the first person that she contacted was the respondent. She interned for him, and he appeared on that scene, I think it's important to note, in less than 3 minutes. His residence is 1.7 miles from the location of the accident at Platten, Michigan. It's also important to note that she was hired on July 10th. On July 23rd, there were 9 text messages exchanged between them. On July 31st, there were 340, and that's way before the Nassif case ever came on a radar. In fact, the crime underlying Nassif wasn't even committed yet. By September 8th, there were over 8,000 text messages. And yes, counsel is right, there is a video, and that video shows that even though Ms. Vargas identified the judge as a judge, respondent's first comments to Officer Call were Judge Simpson as he extended his hand. He approached the officer, he approached the scene. He was a prosecutor, he was a judge, he is a judge. He knows better. He admitted at the formal hearing that he is well familiar with investigations underlying drunk driving cases. He interrupted sobriety tests that Officer Call was performing. And then afterwards, as she is sitting in the backseat of the scout car, he approaches, he talks to her, and he says, "I'm here to help." On September 10th, before the prosecutor even got the warrant request, respondent calls that office and he questions the evidence. He indicates that Ms. Vargas is a good kid in a bad relationship and tells Mr. Lilick that you met her in the courthouse and you will once again work with her on a mediation project. He continues to advocate for her again on September 17th. He questions the evidence once again and discusses his attorney. And he uses phrases such as, "I can't use Joe Simon," who was named by Mr. Lilick. He essentially causes the prosecutor to sit on the case. And it is not until the chief of police on October 17th contacts the prosecutor and says, "What is the status of this case?" And Mr. Lilick says, "I was always going to issue this case, but I was sitting on it until Mr. Shea, the attorney recommended by respondent, contacts me to discuss issues raised by him and the judge." The commission's determination was that respondent had breached numerous standards of judicial conduct, and it recommended removal plus cost. And that recommendation should be adopted by this court. Because contrary to respondent's claims that his actions were not benign, they were extremely improper, not only on the scene, not only with Mr. Lilick, but as this court clearly has noted, the misrepresentations that he had made. And those misrepresentations are both to the commission in his answer to the formal complaint and under oath at the formal hearing. He misrepresented his relationship with Ms. Vargas. 15,000 text messages in 4 months. He may be teaching, he may be on the bench. It's not just the number, it is also the times that they were coming, because they were essentially round the clock. In fact, he had text messaged Ms. Vargas on September 7th, the evening or the afternoon before this accident, when she was in the middle of an online college or law school class. They had exchanged text messages during that time. In fact, and if I can explain, and I'm sure this court notices that and is well aware of it, Respondent is not charged with a relationship. The relationship is what puts his actions in context. It provides a motive and intent for his appearance at the scene. There were 6 text messages between 4:20:09 and 4:23. Now we know at 4:24:33, Ms. Vargas called off the respondent's house. And in fact, when Officer Call arrived...
I would like you to focus on that, because I'm very concerned. I don't care what the underlying relationship is.
Agreed.
All right, so why hasn't the JTC made a fetish out of the fact that there is intense communication between these two? Why isn't that an artifact that is irrelevant? Why does it become important understanding the alleged misconduct in this case?
If I understand your question, why is the relationship important to this case?
Well, the communications.
The communications are important because they show up some kind of a motive for respondent to have appeared on the scene. Respondent from the inception argued that he had absolutely no relationship with Ms. Vargas, that it was only professional relationship, and he only responded to the scene out of some concern. As the investigation was proceeding, it became clear that this relationship is far more than that of a mentor and a student. That relationship
Why do we care about that?
It's not that we care about the nature of the relationship. What we care about is the misrepresentations that respondent had started making with the comment letter. In fact, he never mentioned having any context with Ms. Vargas. In the 28-day letter, he never mentioned having any context.
I guess the question is, why is this all relevant?
Because it provides motive for his actions on September 8th, 2013. It shows the context and the intent behind his showing up to help someone that he has a relationship with.
But is it the conduct or the intent? Like, are we focusing on the conduct or why he did it that's relevant here?
I think both are relevant. His conduct is relevant, but certainly why he went to the scene to take the conduct that he did.
So what if he had just shown up, she's his intern, that's all. And he shows up at the scene, it'd still be interference or it wouldn't be interference. Why does it matter what his relationship is with her? It's interference or it's not interference?
Showing up at the scene of an accident in your own jurisdiction is misconduct.
Okay.
Okay, but why does it matter whether he's showing up because he's having an inappropriate relationship with her or because he's having a completely appropriate relationship with her?
Because he has made misrepresentations as to that, the nature of that relationship.
Okay,
because he had shown up. Initially, as the investigation was proceeding, we clearly knew that there was something more to it. When those phone records appeared and we saw 15,000 text messages, we knew that there was a motive for his appearance on the scene.
But we know he showed up, so we don't need to place him at the scene through circumstantial evidence. We know he's there.
Yes.
So why do you care why he showed up?
Like I said before, because it provides a motive for his appearance at the scene, and it provides his conduct, it puts it in context.
You said that showing up at the scene is misconduct, period. It doesn't matter if it's for good reasons or bad reasons.
Exactly.
If my kid is in an accident and it's 4 in the morning, apparently I should not show up in Ann Arbor because I will be committing misconduct.
If you showed up at the scene of your child's car accident and you introduced yourself as Justice McCormick and you interrupted sobriety test and then you contacted the prosecutor's office, it would still, yes, be inappropriate.
You're moving the hypothetical. We're just asking about the showing up at the scene. You said categorically showing up at the scene is misconduct. Is that correct?
It's difficult for me to simply say yes or no because showing up and remaining at the car would not be misconduct.
But it's not the false statement either, precisely. If he had said he was a longtime friend of his intern and it turned out no, he'd only become a friend 2-3 years ago, I mean, would that have been the kind of material false statement that would have caused you to take the actions that you've taken here?
I'm not so sure that I follow your question. If he was a longtime friend and had
Is it the
admitted that...
false statement per se, or the nature of the false statement that's really a function of what his genuine relationship was with this woman?
The materiality. We're trying to... has the misdirection or misstatement or lie, if it's immaterial versus being material, does that matter?
It does matter.
Okay.
Because...
So if it's an inconsequential, he failed to explain how long the relationship or the nature of the relationship is accurately, that's not terribly material, is it? If he says, look, I have a relationship, I'm concerned about this young lady, and that's why I came. And that's why I was pressing with the prosecutor. I know it was wrong, I shouldn't have done it. But, that's one level of misconduct.
Correct.
You shouldn't interfere with a field sobriety accident test. You shouldn't intrude as a judge and you shouldn't call the prosecutor and sort of chat him up. Okay. But I'm trying to figure out how all these communications become material to the misconduct.
Because he made misrepresentations about those contexts.
So let me ask this question. I think this is something that Chief Justice Young and Justice Markman got at. In standard perjury law and standard false statement law, you have to make a statement, has to be false, you have to know that it's false, and the statement has to be material or relevant. So if you had put a judge under oath and you asked him, have you ever cheated on your wife? And he's been married for 50 years, but in fact, 6 months after their wedding, he had an indiscretion. And he doesn't want to reveal that. And so he says no. But that question, whether he's ever cheated on his wife, has nothing to do with the investigation at all. Do you read our case law to say that his lie, which is a lie, means that he must be removed from office because it's a lie under oath, but not because it's a material misstatement under oath. So you don't think there's a materiality requirement?
No. I think lying under oath, as this court had previously stated, disqualifies a person from remaining on the bench.
But then if that's the rule, I mean, maybe that is the rule of our case law. But if that's the rule, then if I'm the prosecutor, what I'm going to do is I'm going to ask him some question that's irrelevant to the investigation so that he'll lie, and then I can get him removed from office. So, I don't know what the rule is, but
if that's the rule, doesn't that incentivize that kind of gamesmanship to get a gotcha lie on an immaterial matter?
But in this case, there was materiality to this.
Well, that's what we're trying to get at. Why are these communications or the nature of the relationship material to the misconduct charge?
Because the relationship that he had engaged with Ms. Vargas was inappropriate as a judge and an employer.
Okay, so inappropriate is so squishy. Like we don't do inappropriate is a squishy legal term. Help us with why it's relevant to.
Okay. As Justice Young had stated, I'm sorry, maybe it was Justice Zara, who said, you are discussing sensitive materials on a pending matter with an intern over text messages. That in itself is inappropriate. You are contacting your intern at all hours of the day and night. And if I may make a note,
We don't know what the content of these were. All we have is the volume. You're making assumptions about the content. I really am struggling. I mean, I've articulated a number of those cases I wrote. I do believe strongly that a judge lying under oath is disqualifying. But there is, at some point, a concern about whether materiality is somewhere in the zone of consideration here that, and I don't think you have focused on why his motivation for this volume, and I acknowledge it's a vast number of contacts, why that is material to his conduct. He showed up, he has a relationship, whether it's platonic and pure as driven snow or something other than that. He had some sort of emotional relationship that caused him to appear and also caused him to call the prosecutor. Why do we care about his motivation?
because it contradicts his assertions that his appearance at the scene of this accident were not intended to help this intern out, was not intended to get her out of trouble, that his contacts with the prosecutor were not intended to get her out of trouble, and it was only to get a report. It was only to confirm that her story was accurate and that she did not lie to him. Contrary to those assertions, his relationship with this intern shows that his intent in making an appearance at the scene and contacts with the prosecutor were intended to get her out of trouble, and that he did interfere.
What if it's just a clerk?
I'm sorry.
No problem. What if it's just a clerk that he is supporting? What if it's just one of his clerks or one of his interns? I guess you just still haven't answered the nature and scope of the relationship as being relevant to this issue. Why he did it or who he did it for, why is that relevant? We still don't get, what if it's just he likes his clerk? The clerk does great work or the intern does great work, and that's why he did it. Why does the other issues that are more kind of scintillating matter to us?
I think we can assume by his behavior he was trying to help his clerk or his intern.
He didn't dislike her, right?
I think we can take it as
All
for
right.
granted
Okay.
he didn't.
So
So
we assume
we
by
assume
the fact
that.
that he intervened, he was trying to help his intern, right?
Correct.
So what is the rest of this? Why is it material?
Because when an investigation of a judge is initiated by the commission,
Okay.
there is an obligation to be candid with the commission, and that misleading statements to the commission constitute misconduct.
Okay, what was the response that was misleading, that was material to his misconduct? And for the purpose of my question, let's assume that his misconduct for a judge to introduce him at an active drunk driving accident scene, interrupt the field sobriety test, and equally inappropriate to call a prosecutor and chat him up in the way that the judge did. Let's assume for the purpose of my question. So what else was material at that point if those are the misconduct at our issue here? You're frowning, like you don't understand what I'm saying.
Well,
I'm saying the 15,000 communications between these two individuals, why are they relevant and material?
When a judge answers the commission's inquiries in a comment letter that the only context he had with Ms. Vargas was in social settings and no other context. When he responds to the commission's 28-day letter inquiry, reaffirming that that was the only contact he had with her, and then the commission comes into possession of 15,000 text messages, it is relevant because it shows that his responses to the commission in those two inquiries were false, and false responses to the commission may constitute misconduct.
Even if they're immaterial.
Yes.
Okay, that's
I want to
your
understand.
position.
Now, he says, my only sort of contacts with her, sort of social with others. And so if he's having text messages, that's a false statement then?
They're not only text messages. They are
Phone calls.
Going on at 1:30 in the morning, as you noted, Justice Young, all hours of the day and night. And if he makes representation that his only contacts with her are social together with other people, then yes, it is false.
Why is it that we haven't been able to get to the substance of those communications? Was the phone involved lost or destroyed, or was
No, my understanding is that the only person who can make a request for those would be the owner of that phone, and that if we want to get them, we can only get the list of calls, but not the contents of the text messages.
Did you subpoena the
Yes.
judge to get the content?
No. No, the commission did not authorize anything other than obtaining a list of the contacts and the phones.
Can I ask you, I feel like you've expanded the list of misstatements you want us to, or lies, or however you want to, that you want us to consider. I thought we were talking about the specific allegations before us are what he said about his reason for calling the prosecutor, and what he said about the contact that night between 1 and 4 a.m.
Right.
You now want us to start considering what was said in a 28-day letter, or what was said, and that's not before us, right?
No. I'm not saying you should. What I'm saying is
why
I
were
was
we talking
responding
about
to
that?
Justice Young's question, but the misrepresentations that were determined by the commission were his reasons for coming to the scene, the Nassif issue, because if I can also tell you that Nassif did...
I think you really need to focus in on the serious lies and explain why those are consequential. Certainly, if the misconduct is the intervention at the scene of the drunk driving accident and the intervention with the prosecutor, those are the core misconducts. So what we're trying to figure out is there what did the judge say that was false about those events?
Certainly. There was a misrepresentation as to the reason for coming to the scene. He testified that it was out of concern for her ex-boyfriend, and the first thing that happened on the scene is that the officer told him she was fine. He never mentioned anything about a boyfriend to the officer. He comes to the scene out of concern that the boyfriend might have caused this accident, and yet he never mentions anything about that. He also misrepresented that he wanted special consideration in making contact with Mr. Lilick, or on the scene. And on the scene, when you come and you're a judge, and when the officer says, look, I'm just trying to make sure she's okay to drive, and your response is, well, does she just need a ride or something? As the master and the commission had determined, that clearly is an implication or an insinuation, look, I'll just give her a ride home.
That goes to whether it was an inappropriate thing for him to be there in the first place, doesn't
Correct.
it? Okay.
But I thought you were asking me as to misrepresentations regarding those incidents, and that's what I'm replying to. As to the contact with Mr. Lilick, he testified that he simply wanted results of the breath test on the scene. The videotape actually shows that Officer Cole told respondent that she blew .13.
As she told him when he talked to her in the back
in the
seat of
car, correct. And even if, let's assume that was not the case, he certainly had that report by September 13th, and it was re-emailed on September 15th. And yet he continued to advocate on her behalf on September 17th when he discussed attorneys.
Let's stop. The first contact with the prosecutor, that's a significant event. And it's sort of presumptively inappropriate for a judge to call a prosecutor about a case of this nature, correct?
Correct.
All right. So the focus then is his justification for calling. You can either say, I'm sorry, I shouldn't. My concern about helping this young lady overcame my prudential judgment. End of story. Or you can try and justify why that wasn't inappropriate. What happened here?
And here he made an attempt to justify, and that justification was not
Worthy of belief.
not worthy of belief.
And that was because of the justification offered. He wanted to make sure that the breathalyzer was as she represented.
Correct.
Can I ask, was the inappropriate, you believe that Judge Simpson's, the objective nature of his conduct was wrong on the evening in question, is that correct?
Yes.
In your view, was it exacerbated at all by giving some motive to what he did that night?
Yes.
Again, I ask you, you believe that the objective nature of his conduct that night in speaking with the police and the next day in speaking with the prosecutor was wrong. How was it exacerbated by what you believe you know about the relationship between Judge Simpson and his intern? How was it exacerbated? Was it exacerbated? Was it not sufficient that you knew all that you knew about the case by virtue of his objective conduct that night and the next day?
I still have James and Justin and Adams that are in my mind to say that a judge who lies under oath, that a judge who lies to the commission, it just exasperates the entire situation.
I understand, but we're trying to at least focus on the conduct, the misstatements, lies, etc., that are directly related to the misconduct.
In all of those cases, in Justin and in Adams, the judges lied repeatedly under oath about matters that were highly material to the other misconduct. That was I'm not saying your new rule that you can lie about anything that ever happened in your whole entire life and you should lose your job shouldn't be the rule. Maybe it should. Maybe this court will say it should. But so far, what those cases have said is that those judges lied repeatedly about matters that were highly material to their other misconduct. So can you make that connection for us here?
Well, if we go back to Adams...
Look, if you want to argue Adams, go ahead, but your best shot right now is to explain why the consequential misconduct is related to some misstatement the judge made. That's what we're looking for.
The misstatement that he made, you're referring to the text messages misstatements?
The ones that you care about. You're the one that tells us what you think are misstatements. And we haven't yet even said we agree with you that they're misstatements, but you're the one that tells us.
Well, the misstatements that he had made, I mean, we're talking about his testimony regarding what happened when Ms. Vargas had called him the first time, right immediately after the accident.
Why don't you go to the most consequential lies in this record? Tell us why they're consequential.
Upon receiving the call from Ms. Vargas, respondent testified that she spoke Spanish, and the only two words he understood was Michigan and Burger King. The tow truck driver who hit her, who was there right on the scene, said she wasn't upset, she wasn't speaking
foreign.
Do you
understand the concept of materiality?
Yes, I do.
Maybe not. Go to the most critical lies in this record.
The most critical lie in this was purpose for his appearance on the scene, the purpose for contacting the prosecutor.
Okay. What did he say his motivation for contacting the prosecutor was, and why was that a lie, and why was it a material?
The purpose for contacting the prosecutor, he indicated, was to confirm her story, to verify the breathalyzer, and to determine whether he wants to keep her as an intern and not to interfere with the prosecution. All of those were lies.
So they're lies because we can know for sure that his motivation was other than he thought it was. We're now saying it's not that hard to follow. Let me try again now. We're saying, you sneered at me, so I'm trying to.
No, and I'm sorry, that, no, I
you did.
want to make sure that I answer the question.
Okay, well, the question is, you're saying that what he said about his own motivation is a lie. This feels a little hard. It's not like if he said, I didn't call the prosecutor, never happened, didn't happen. Easy case, that's not true. We know he called the prosecutor, right? But what you're saying he lied about is why he called the prosecutor. And you might be right, because maybe, we're all human beings. We have complicated, things that motivate us, right? The world, people are complicated. But we have to determine that he lied about his motivation, and that is the same kind of lie that we have held in other cases is sufficient to remove someone from office?
Well, if I can answer the first part of your question, how do we show that it's a lie? Because when you discuss attorneys and you make phrases or you make comments like, I can't use Joe Simon, that clearly shows that, I'm sorry.
That shows that it seems to me there were more complicated, or it might seem to you, or it might seem to some people that there are more complicated motivations for why he's calling, but not necessarily, I don't know how we know what he believed about his motivations. You see what I'm saying? This is like a complicated, way to say this is a job-ending lie when it's about someone's motivations instead of, I didn't call the prosecutor, didn't happen. That's easy.
Yes, it would be easy.
Yeah.
And perhaps this is not as easy, but
Okay.
while I say it's not as easy, I'm not saying that it's not as clear.
Okay.
Because it's still clear that when you make those phone calls, when you say the reason that I'm calling the prosecutor is because I want a report, you got your report. Why are you still calling? There is no reason for you to discuss attorneys. There is no reason for you to say, I can't use certain attorneys. So yes, it may not be as easy, but that doesn't mean it's not as clear. And if I may simply use the jury instructions, sometimes circumstantial evidence is stronger than direct evidence, because circumstantially, if a child comes to you with cake around his mouth and says, I didn't eat the cake, you know they ate the cake. These terms, these words, these actions may not be easy, but clearly they show that the motive was not to obtain the report.
I just have one question. I just want to ask a hypothetical, because I want to go back to the beginning, because I think this is really clear, because this is not just about this judge, but it's going to affect all judges in the state. And I want to go back to this accident situation. So I want to give you a hypothetical. Let's just say hypothetically, I always love to use my town, Birmingham. Let's just say, I love it, it's my thing. Let's say hypothetically I'm with some very close friends, and we're in Birmingham. And, we're having dinner, and we notice that a ticket's being put on the person's car who has come to meet us. And so we run over to the person who's giving the ticket, and we say, we say, hey, I don't think that's right. We weren't here as long as you're thinking we're here. Now, I guess my question is, if I were to accompany the friends that I'm having dinner with, and we run over to the person who's giving us the ticket, am I not allowed to do that? Am I not allowed to be there? Am I not? I mean, let's just say, let me give you two hypotheticals. Let's say I say my name is Judge Bernstein, because that's my title. Have I now committed a violation?
He just demoted himself. He's only a judge.
Judge, whatever. Yeah.
But nobody knows what a justice is.
Right.
They know a judge is not a justice.
But I'd like to know the answer. So if you're, it's our title. So, if you were to say, hi, I'm Judge Bernstein, and and you're with the people and you're arguing over the ticket, is that inappropriate?
Are you arguing over the ticket, or are they arguing over the ticket?
Well, I think let's say hypothetically I'm arguing in conjunction with them that we were not there as long as they think we were there.
And if you say, I'm Justice Bernstein, I think it's inappropriate, because you're now invoking your office to perhaps influence the decision of that officer and maybe tear up that ticket.
But
okay,
that's a complicated. I mean, every officer in Ipsy Township knows who Judge Simpson is, right? I mean, that's just, it would be weird for him to say, I'm Cedric Simpson, because they all know he's Judge Simpson. So
Right. Like, what about the situation where the officer knows who you are? Like, they know who you are. So now let's take away the title. You don't say you're Justice Bernstein or you're Judge McCormick. You just say, hey, I'm Judge. It's been a rough day. You just say, hey, I'm Richard Bernstein. I'm Bridget McCormick. You know, I live in this community, whatever. You just introduce yourself by name, but not title. But you're still advocating for the fact that you think the ticket's going to be wrong. Are we now subject to sanctions?
And you have not introduced yourself as a judge, but you're
Correct.
saying they know you as a judge?
They know who you are, yes.
You know what? No, I don't think you're trying to assert your office to influence the situation. The minute you say, I'm Justice Bernstein or I'm Justice McCormick, that brings it into a totally different situation. And you know what? You can't look at this as an isolated point in this continuum, because that is not the sole item that respondent had done. That's not his sole
Is this an
act.
official advisory opinion of the Judicial
I know.
Tenure
I'm
Commission?
sorry?
Those of us who live in small communities need one, because the sheriff that pulls me over knows who I am. So I have to say, like, for right now, I'm
There's your
Bridget.
pictures in the post office. Thank you very much. The case is submitted.
When do we come back to you, Jeff?
Quarter of.